Hello, and thank you for joining this tutorial on the Supreme Court and Court of Criminal Appeals emergency order concerning the coronavirus pandemic. The purpose of this tutorial is to explain the order in more detail and to emphasize what you must do, what you're required to do under the order, and what you may do. I want to mention at the outset the reason why this order was issued. The on Today is Tuesday, March 17th, 2020. Last Friday, March 13th, the president declared a national emergency as a result of the rapid spread of the coronavirus throughout the United States and the outbreak of the disease caused by the virus, which is referred to as COVID-19. We are under a national emergency. That is serious. It is not hyped up. It is not a result of media hype. It is a threat to public safety. The governor of Texas, Greg Abbott, also declared a state of disaster last Friday, March 13th, in all 254 counties in response to the imminent threat of the COVID-19 pandemic. The governor mentioned yesterday, Monday, March 16th, that we can expect to see an exponential increase in the number of COVID-19 cases. The reason we're going to see an increase is because we have engaged in testing on a much greater scale than we had been doing. Without the testing, we don't know who is affected by the virus and who is not. They are now aggressively implementing testing, and we are going to see the number of infected persons rise. As the governor said, this is going to occur exponentially. Every couple of days, the number is likely to double. The reason that these measures have been taken is to try to prevent the spread of the disease and to prevent our hospitals from being overwhelmed, which is what is happening in Italy currently. So I do want to mention that this is not media hype. This is a real public threat, and that is why both the president and the governor have taken the actions they have. The government code authorizes the Texas Supreme Court and the Court of Criminal Appeals to modify or suspend procedures for the conduct of any court proceeding affected by a disaster during the pendency of the disaster declared by the governor. That is what prompted the Supreme Court and the Court of Criminal Appeals to issue this emergency order. They are exercising authority provided to them by the government code in a national disaster. A copy of the emergency order itself is posted on our website at tjctc.org on the coronavirus link. So please go there and please do read the order. But what I would like to do is explain in a little detail what you are required to do under this emergency order and what you may do. The number one thing is that the order requires all justice courts, and this is subject only to constitutional limitations, which we'll discuss in a minute. You are required to take any or all of the following actions without a participant's consent in order to avoid risk to your court staff, to parties, to attorneys, to jurors, and to the public. And I would also say to yourself, of course, to avoid risk of being infected by this virus. These are the actions that you are required to take to avoid that risk. First, you must modify or suspend any and all deadlines and procedures for a period ending no more than 30 days after the governor's state of disaster has been lifted. What that means is you should postpone trials and hearings in most cases. There are some cases that are considered essential, hearings that are essential. I will come to that in a minute, what are essential. But any non-essential hearings, you should postpone those trials or hearings to to within 30 days after the state of disaster has been lifted. Now, you can conduct hearings if it's safe, for example, by video conference or telephone conference, and we'll discuss that also in a minute. But live hearings with persons who may be infected by the virus, those should not be taking place. Second, you can allow or require anyone other than a juror who is involved in a hearing or other proceeding to participate remotely. So you can require them to participate by telephone conference or video conference. We are posting today on our website some helpful information which will assist you in obtaining programs to conduct hearings by video conference. It actually can be very simple, and we are having information available to you today to assist you so that you can conduct more hearings, in fact, all hearings really, by video conference or telephone conference. And we strongly urge you to do that. A third thing that you must do is to consider sworn statements that are made out of court or consider sworn testimony given remotely by telephone conference or video conference. Again, this is in order to protect the safety of the court and yourself and any participants and the public from the spread of the virus. A fourth thing that you must do is to conduct proceedings away from the court's usual location, again, if you need to do that to protect public safety. But those hearings need to be in the same county and with notice and access to the participants and the public. You should also require every participant to alert the court if the participant has or knows of another participant who has COVID-19 or flu-like symptoms or a fever, cough, or sneezing. Until we have more widespread testing, we think the best procedure is if someone has a flu-like symptom, then they should be isolated. They should not be allowed to come in contact with your court staff, with yourself, or with other persons who come in contact with the court staff or yourself. Until we are able to implement more testing and to identify those people who are infected with COVID-19 and isolate them. If someone has flu-like symptoms, if they have a fever or a cough or sneezing, just assume that they have the virus for now and take measures to protect yourself. Finally, you can take any other reasonable action to avoid exposing the court proceedings to the threat of COVID-19. Those are things that are required in order to avoid the risk of infection of the virus. What may you do? What are you allowed to do? The emergency order allows you to take any of these actions in any civil or criminal case. It allows you to extend the statute of limitations in any civil case for a period ending no later than 30 days after the governor's state of disaster has been lifted. So what are some of the best practices that we are suggesting? First of all, we do strongly suggest that you postpone all court hearings and trials other than essential hearings, unless you are able to conduct them by telephone conference or video conference. If you can do that, then you and your court staff and personnel are protected. But if you cannot conduct them by telephone conference or video conference, you should postpone them. That is what the order is saying. What are essential hearings? Essential hearings include, first of all, criminal magistration proceedings. Those can be conducted by video conference, and we again urge you to conduct those by video conference. Mental health proceedings, that may include emergency detention orders, but again, those can be conducted safely remotely. So instead of having the person who's requesting the hearing or filing an affidavit appear in front of you, do it remotely. Do it by video conference or telephone conference. Juvenile detention hearings are essential hearings, but again, those are not normally performed by a justice of the peace. They are performed by the juvenile court unless the juvenile court is unavailable. And in that case, a justice of the peace may conduct a juvenile detention hearing. But again, please take measures to make sure those can be conducted safely. Eviction cases are not considered essential court proceedings. and therefore those must be postponed to avoid risk to the court staff, the parties, and the public. Again, unless they are conducted by telephone conference or video conference. With respect to inquests, we believe those should be conducted remotely by telephone whenever possible, and always if there is a risk of any risk of infection from the coronavirus. Magistrations, as I mentioned earlier, should be conducted by video conference. If you do not currently conduct them by video conference, we have resources available to assist you in learning how to do this. It's really quite simple. We are putting on our website today a tutorial on video conferencing and remote hearing. So please take a look at that and use that. We also have judges available to assist you. Judges who do conduct magistrations by video conference, you can call them and get assistance from them directly about how they've done it to make sure that they're always able to conduct video conferences, to conduct magistrations by video conference. So please take advantage of those resources. We also suggest that you issue a standing order that applies to all proceedings as long as the disaster is in effect. An example of a standing order is also on our website. And in that standing order, the justice courts in that county have stated what they believe essential court proceedings are, and currently they are including writs of reentry, writs of retrieval, writs of restoration, magistrations of defendants in custody, and issuing burial transit permits, and issuing birth certificates and repair and remedy cases. That's it. They are postponing all eviction cases. So please take a look at that standing order, and consider whether you believe a similar order would be appropriate for all justice courts in your county. We do think that is something that you should consider at this point. The bottom line is to protect your own safety and public safety. This is a serious threat. It is not going to go away immediately. The president said yesterday that it may be with us until July or August. So we urge you to please do take measures to protect yourselves, protect your court personnel, also your constables. We will be coming out with more information on procedures that you can implement to minimize the risk of exposure to yourselves and your court staff. So please take advantage of these. We are available for questions. If you do have any questions, we are available both with respect to the legal board questions as well as call-in questions. The training center is open and operating, and we welcome your questions. So if you have further questions, please do contact us. I hope this is helpful. We will be coming out with more information in the coming days and weeks as developments occur. So thank you, and please be safe and protect your courts and your staff and yourselves. Thank you very much.